Number 3, there needs to be a Great Council of Chiefs, which must consist of persons appointed by the President on the advice of the Minister. In the original 1944 Act, that word "on the advice of the Minister" is not there. The wording is that that persons were appointed by the Governor General. In this particular clause, why it was very important to refer this bill to the committee, would have been more consultation done on whether the powers now given to the Minister to advise the President in any appointment, how will it be vetted? Because a Minister, we all know, is a politician, a political appointment, and could influence, a political decision could influence the appointment of any GCC member, given that they will be advising the President in any of the appointment. If you look at the original Act, that is not there, so that is a new insertion on the advice of the Minister. The second thing that I would like to also share is on clause number 4. Clause number 4, it talks about when a particular question or recommendation is brought to the Council, through the Minister, the powers that are there in the original Act, that it must or should be referred to the Great Council of Chiefs. In the current form, it has used it has somewhat weakened the Council in the words in clause 4, where will be inserted, if you read clause 4 there, that is section 4 of the Principal Act, subsection 4 of the Principal Act, will be amended to insert, it may refer such questions to the Council. So that has somewhat given power to the Minister, and that has, in somehow, the original Act would talk about that the Minister needs to refer that to the Council. In here, the Great Council of Chiefs is like being undermined because the powers will be with the Ministers. These are some of the wordings that are there that is really, really important. And clause number 5, if you go to clause number 5 of the bill, and if you go to the Principal Act, and that is in there's a poor drafting done in terms of the word that is there, where it appears, wherever it appears. And the word that has been referred to, that is clause 5, is the word "of the." If you look at that particular section in the principal bill, there's 3 times the word "of the" that appears in that whole section number 5. But how it is drafted here, it only refers to 2 occasions. That's in the subsection A and B that refers to this. So there is poor drafting too done there that needs to be done, redone. And the other thing that needs to be looked at is in clause number 6. Clause number 6. That is in clause number 6, where you have the introduction of a permanent secretary at the end in the procedures of a bill that comes through concerning iTaukei that comes through the Council after the discussion by the Great Council of Chiefs. It's brought back to the board to make its papers before it goes to cabinet. There is, in the original Act, it talks about, after it comes from the GCC, it goes to the Clerk of Parliament. That has been removed in this particular amendment. And the introduction of the permanent secretary that is in the form of the bill that we have. The GCC had a standalone procedure, legislative procedure, that after they discuss any legislation concerning iTaukei, it comes from the Minister, it goes right to the Clerk of Parliament or the Secretary General of Parliament. That has been removed in this clause 6 of the bill. And I hope the Attorney General will really look into this, because these are very important questions. If we had taken the bill to the committee, we would have picked it up and also compare with the original Act, compare with the 2012 decree, and compare with the current form of the bill that you've introduced. And we'll also look into the recommendations of the review committee of the Great Council of Chiefs, so we can make a better form of the bill that is long-lasting, so we don't come back running into this House for other future amendments. The last part is the clause number 7. Clause number 7, the bill says that it's just consequential amendments. But there is another very important thing that this particular bill that is removed, and that is if you look at the iTaukei Trust Fund, the membership of the board, that I'll refer you to section 7, subsection 3. The board consists of 8 members to be appointed by the minister, including A, 5 members nominated by the GC. That veto power nominated by the GC has been removed by this particular bill, which now says, that's in F7, after 5 members must have a suitable qualification and work experience in any of the following areas: investment management, engineering, information and technology, human capital, tourism and hospitality. That is a new insertion, and that has taken away the veto power of the GCC, that where 5 members are nominated by the GCC into the iTaukei Trust Fund. And I urge the government to relinquish the bill that is there. If it was done through a rush, I would like government and the Attorney General to withdraw it and refer back to the committee so we can fix and repair the bill as it is.
Thank you.